So this person has posted a version of this comment several times in several of my videos as if it were some kind of a gotcha moment. So I figured I'd give him the 3 minutes of fame that they're clearly looking for, because in addition to being a fairly common, silly attempt at showing us that the Second Amendment, shall not be infringed, comments like these also underscore how so many Americans think that constitutional rights are just unlimited rights when they're not and have never been so, because they're always subject to compression when compared and balanced against other constitutional rights. So since this person is talking about cars, let's take a look at cars and the Fourth Amendment, shall we? If we treated the Fourth Amendment, the right to privacy, like we do the Second, we would think that there is no way that the government could stop and search our car unless there's a reasonable suspicion that a crime has been committed. And yet, the Supreme Court says that when the right the state is protecting is the safety of its citizens, then police can stop random cars to check for drunk driving or alcoholic content in the car, even when there is absolutely no reason to believe that that particular car is drunk driving. In Michigan v. Sitz that you see behind me, the Supreme Court decided that even an important right as the right to privacy indicated in the Fourth Amendment is not an unlimited right, and it is subject to constriction, to limitation, when the safety of citizens is at stake. The case hinged around the right to privacy on one side, and specifically the right of citizens to not be stopped and searched without probable cause, and the right of a state, Michigan in this case, to protect its citizens by conducting random field sobriety tests on motorists. Well, the court decided that in the balancing act between the right enumerated in the Fourth Amendment and the right of citizens to be safe, the latter, the right of citizens to be safe, wins. In fact, in the 6-3 decision, the court points out that, and I read, no one can seriously dispute the magnitude of the drunken driving problem or the state's interest in eradicating it. Essentially, what the court is saying is that when it comes to the Bill of Rights, a state has a duty and a right to balance the compression, in this case, of the right to privacy in the Fourth Amendment against the benefits obtained by stopping cars randomly, even when there is no indication of a crime being committed, and therefore technically in violation of the Fourth Amendment. The very same thing could be said about the Second Amendment and laws like mandatory mental health evaluation, federal implementation of red flag laws, and mandatory proof of proficiency. And that concept could also be applied to requirements that are proportionally stringent to the danger that the firearm poses. So, for example, handguns could have less stringent requirements that say owning or possessing an AR platform, which is designed for precise and high firepower. Unfortunately, the NRA has conditioned so many Americans to incorrectly believe that any law that limits the ownership or possession of any firearm is inherently unconstitutional. And even more appallingly, some politicians who are constitutional lawyers are paid by the NRA to continue repeating this incorrect concept. So please, let's stop with the flexing comments that focus on the shall not be infringed part of the Second Amendment when there are 23 other words in it that so many Americans seem to conveniently forget.